but it is extending towards skill development, experimental learning, interdisciplinary engagement, and professional competence. On this context, today's panel discussion seeks to explore the roadmap for transforming legal education through curriculum modernization and practice-oriented learning. We are deeply honored to have with us an esteemed chairperson, SUNIL Thomas sir, and distinguished panelists, Advocate NAGARAJ Narayanan sir, Professor Dr. G.B. Reddy sir, and moderator, Dr. ARATI PM ma'am. I kindly invite everyone to the stage. Our session is chaired by Honorable Justice Sunil Thomas sir, former judge of the High Court of Kerala and presently the judicial member of the Central Administrative Tribunal, Ernakulam branch. Justice Sunil Thomas sir is widely respected for his remarkable contributions to criminal law, profound expertise in civil law, particularly the Transfer of Property Act, equity and judicial administration. Known for his clarity in legal reasoning and unwavering commitment to justice, he has delivered several notable judgments during his tenure at the High Court of Kerala. He also serves as an adjunct professor at the National University of Advanced Legal Studies, KOCHI, and continues to contribute immensely to the legal academia and judicial discourse. We are also privileged to have with us Professor Dr. G.B. Reddy sir, Vice Chancellor of the National University of Advanced Legal Studies, KOCHI. Sir is a distinguished legal academic and scholar known for his significant contributions to constitutional law, human rights law, public law, and legal education in India. Through his exemplary roles as professor, author, researcher, and academic administrator, he has played an influential role in strengthening legal scholarship and advancing contemporary legal education in the Indian legal community. We are also delighted to have with us Advocate NAGARAJ Narayanan sir, Bar Council of Kerala member and the Director of Kerala Law Academy. Advocate NAGARAJ Narayanan sir is recognized for his active engagement in legal education, advocacy training and institutional initiatives that promote practical and professional legal learning. His contributions towards strengthening practice-oriented legal education and mentoring aspiring legal professionals are truly commendable. Our session today will be moderated by Dr. ARATI PM ma'am, Assistant Professor, Mahatma Gandhi University. Before joining the School of Indian Legal Thought, Dr. ARATI ma'am was associated with the Council for Social Development, New Delhi. She completed her doctoral research on gender bodies, medicine and law, a study of selected case laws from India, and has extensively worked in the areas of health law, gender justice, reproductive rights, and public health policy. To formally commence today's proceedings, I invite Ashwati Devi, Joint Convener of the Bhagat Singh Study Circle, to deliver the welcome address. Ashwati, please.
Good afternoon, everyone. It gives me immense pleasure and honor to welcome you all to this panel discussion on the theme Roadmap for Transforming Legal Education through Curriculum, Modernization and Practice-Oriented Learning. Legal education occupies a unique position in society. It is not merely a means of imparting knowledge of laws and legal principles. It is the foundation upon which the ideals of justice, constitutionalism, and the rule of law are sustained. The quality of our legal institutions tomorrow depends significantly on the quality of legal education we provide today. As we navigate an era shaped by technological innovation, globalization, evolving professional demands, and changing social expectations, legal education is called upon to reinvent itself. The legal profession of the 21st century requires graduates who are not only proficient in legal doctrine, but also equipped with practical skills, interdisciplinary perspectives, technological competence, and a strong sense of social responsibility. The theme of today's discussion invites us to reflect on the transformation. Curriculum modernization is not simply about revising syllabus. It is about reimagining legal education to make it more dynamic, relevant, and responsive to contemporary realities. As law students, we stand at the heart of this conversation. The ideas, perspectives shared today have the potential to shape not only our educational experience but also the future of the legal profession itself. We are deeply privileged to have with us Justice Sunil Thomas sir, former judge of the High Court of Kerala, who will chair this session. Throughout his distinguished judicial career, Justice Sunil Thomas sir has contributed immensely to the administration of justice and the development of legal thought. His vast experience and wisdom will undoubtedly enrich today's deliberations. Sir, we extend our heartfelt welcome to you. We are equally honored to welcome our esteemed panelist, Professor Dr. G.B. Reddy, Vice Chancellor of NUALS, KOCHI, is one of the most distinct voices in legal academia. Through his contributions to legal scholarship, research and academic leadership, he has played a vital role in advancing legal education in India. Sir, we are delighted to have you with us. Advocate Nagaraj Narayanan sir, member of the Bar Council of Kerala and Director of KLA, brings to the discussion the invaluable perspective of a practicing legal professional and institutional leader. His insights into professional training, legal practice, and the evolving demands of the profession will greatly enhance today's dialogue. Sir, we are honored by your presence and we welcome you to this session. We also extend a warm welcome to Dr. ARATI PM, Assistant Professor at the School of Indian Legal Thought, Mahatma Gandhi University, who will be moderating today's session. Her academic expertise and thoughtful academic guidance will undoubtedly facilitate a meaningful and engaging discussion. Ma'am, we are grateful for your presence and we welcome you to this session. On behalf of the College Union 2025 Bhagat Singh Study Circle and the Law Journal Club, the faculty, the students of Government Law College Ernakulam, I extend a sincere, heartfelt welcome to all our distinguished guests, delegates, participants, and members of the audience. Your presence here today reflects a shared commitment to strengthening legal education and preparing future generations and of legal professionals for the opportunities and challenges of a rapidly evolving world. With great respect and gratitude, I welcome all of you to this panel discussion and wish the session every success. Thank you.
Thank you, Ashwati Devi. Without further delay, I now invite moderator Dr. ARATI PM ma'am to formally commence the panel discussion. Ma'am, please.
Yeah, I think already the session's handling conveners discussed the theme of today's panel discussion. Today we have three eminent scholars from different stakeholders in the legal education in contemporary India. What I think is probably we can start with Sunil Thomas sir. And I thought I will give you two rounds of comments so that then we can open the floor for further comments and queries. I think we all agree that there are some issues in the current way of teaching and learning happening in different academic institutions which is focusing on legal studies and research. Probably we can start with, from your own opinion, what are the problems you are identifying with the current legal studies centers and institutions? Because it's not a homogeneous institution we are having in India to learn law. It is very heterogeneous. Probably Sunil Thomas sir can comment more on. He comes from a time where we have a homogeneous way of learning law. Now we have structural inequalities within the legal studies structures. So how do you see this difference? And to you, what are the problems you are seeing in the current legal teaching and learning scenario?
Thank you, Dr. ARATI. Good afternoon to all of you. See, what I find is that one thing before I commence, I should congratulate the organizers for selecting a good topic. See, this is a matter of general importance, and it is very rare that students who organize a function like this take up the topic of how to change, revolutionize, how to modernize the curriculum so as to achieve the objects which the legal study intends. So that's what attracted me first. Secondly, before going into the question, how to change, what is the roadmap for a development or changing the curriculum, we should understand what are the requirements. See, I come from, as Dr. Arathi said, I come from a conventional practicing lawyer at a time when we had a very, very limited field of law, either civil law or criminal law. Then came the family courts, etc. Then there has been a substantial change in the legal profession, especially when new statutes came, new tribunals came, new courts came, and that has undergone more challenge, which I will say, I will attribute to three specific reasons of sociological importance. The first is the introduction of Section 89 of the CPC. Till then, it was a court-centric adjudication process which was conceived. When Section 89 was introduced, for the first time, statutorily we recognized alternative dispute resolution mechanism. We opened the threshold of arbitration, conciliation, and mediation, which are the most prominent alternate mechanisms which we have find now. So that the earlier conventional method of litigating in court, settling the matter, is undergoing a change in India. You will know that in European countries it is 90% mediation-centric disputes that are being settled, whereas in India it is just the reverse. So it has become expensive. That's why we are promoting mediation and arbitration also. Now that has gone into another aspect of international contracts now. That I will say that mainly attribute to the economic liberalization that we had sometime in 90. When economic liberalization policy was introduced in India and gates were thrown open to multinational companies to India and others to invest outside, what I find is that it has become a very, very complex situation. Complex in the sense that the nature of disputes that arise have considerably changed. One is international contracts, a contract involving several causes of action, several jurisdictional issues that have come up. So that is one issue that we should be capable of. The other day, one senior judge of the Supreme Court who is now dealing with international disputes said, Singapore, which is the hub of mediation center, 95% is international disputes. Based on international contracts, 5% only the domestic disputes. Whereas we don't have that. We have not developed to that extent. So we should get more expertise, knowledge and studies on arbitration, mediation, conciliation. What are the new mechanisms that are going on? Worldwide it has undergone tremendous change. Then I said economic liberalization giving rise to these type of... See, it is not something which you will find, it is not a strange thing to you. The other day I met a businessman who is a small-time businessman in Kerala who is dealing with sale of chemicals. You know what is the business that he is doing? He purchases minerals from Ukraine that is transported to China. Because China, there is an area where they permit segregation of highly dangerous explosive substances. So mine ores are taken in a container, shipped to China, where it is segregated. Then it is transported to Hyderabad. Then I asked him why he is doing it. That's for packing. Then he said, because that state gives me the maximum tax benefit. When a product is converted and manufacturing process is going on, that state gives a lot of incentives. So what are the issues that we are coming in a small scale businessman in India? multinational contracts are there. Cause of action in relation to dispute arising in various countries, Ukraine, China and India. Thirdly, interstate taxation disputes will come up. International transfer of money and will also come into play. So these are the complex which we are now going to face. The third issue I will say, the third cause I will say, that is a now information technology revolution that has taken place in India. See how tremendously the situation has changed. And because of that, the nature of the disputes that arise now, the nature of the crimes that are occurring in India have also undergone considerable change. One person in Nigeria hacking your account here, the question is how is to be dealt with? The investigation aspect, the charging aspect, and also the trial. So these have given rise to various complex issues. So definitely that lead to the question, are we equipped to meet those challenges? All other ancillary challenges are there, but I will say that these are the main three issues that gave rise to different complex situations which may lead to different types of cause of action, different types of litigation disputes, different jurisdictional issues and different legal issues also. Are we equipped for that? So there are a lot of areas where we need a lot of improvement in the curriculum. Cybercrime, artificial intelligence, intellectual property rights, etc. So these are the issues which I feel that should be discussed. I think Professor Reddy, who is an expert on the educational aspect, and Mr. Nagaraj, who has got twin role as a lawyer and as a member of the Bar Council, who lays down the guidelines for code of conduct, curriculum, etc., they will be able to throw more light on it. I am passing it on to Professor Reddy.
Sir, G.V. Reddy sir, for you being the Vice Chancellor of NUALS, the concern is probably, we all know that early 1970s there were discussion about improving the legal education. The first time we discussed in the public sectors, colleges and the problems with that. And as part of that, revolutionizing the legal education in India, in 1987 we started NLS Bangalore, and then we have now many national law universities all over India. So the major mandate was to improve the quality of litigation and to develop publicly committed lawyers in the country. So reflecting on the mandates given to the national law universities, where are we now and how do you see the current scenario? Have we achieved the objectives of national law schools, and your reflection on that?
Thank you, ma'am. Respected panelists, Justice Sunil Thomas sir, Sri Nagaraj Narayan, Dr. Arati, the dignitaries of the days, and dear students, thank you, a big thank you to the organizers for inviting me over here to share some of my thoughts. Now coming to the question raised by Dr. Arati. When Harvard Law School was established long time back, similar debate took place as it took place in 1980s when National Law School of India University was established by the Bar Council of India Trust. Today we have 27 national law universities with different nomenclature used. And probably they were created on the lines of IIMs and IITs. They wanted the centers of excellence. And Professor Madhav Menon played a vital role in that. But now it is almost 40 years now since the National Law School system came into existence. And there is one clear development where a disparity is seen, because we have nearly 1700 plus law colleges in India. There are traditional law colleges. Your great college established in 1894. My own department established in 1899 back in Hyderabad in Urdu medium. There are number of such traditional law colleges, traditional state universities. Now we have some central universities. We have global law universities like Jindal, BITS and all. Then we have the national law universities. And in terms of the purpose of legal education, I think there is a clear distinction among the students who are joining these courses. Once upon a time, law was the last resort. If there was no admission in any other course, then they used to join the law. Today, law has become the first resort. It is a chosen profession, one of the most respected professions. Second point is, as far as national law universities are concerned, long time back, S.P. Sathe wrote a very thought-provoking article in Economic and Political Weekly, calling them as elite institutions, criticizing that they have not met the purpose for which national law schools have been established, only to cater to the elite sections, maybe within quotes, of the society, only to produce lawyers to join the corporate sector, not to take care of the litigation as mentioned by Honorable Justice Sunil Thomas just now, or in helping the justice delivery system, or in creating socially relevant and professionally competent lawyers. That particular allegation still continues even after 40 years of their operation. This is one important aspect. But when the concept of LPG has dawned in 1990s, the liberalization, privatization and globalization, the avenues for the legal professionals increased, improved. Today we are talking about LPOs, legal process outsourcing. India is one of the biggest beneficiaries of the LPO industry in the beginning of this century. Second, most of the Indians today, they are in fact working with international law firms, Tier 1, Tier 2 and Tier 3 law firms in India, and very few of them are, especially the national law school products, hardly 10% they are joining the legal profession. The scenario is changing in certain law schools now. But in majority of the law schools, they think that their objective is met when there is a placement in the fourth year or final year. As simple as that. Then what about the litigation? Can any person be like Mr. Shamnath Bashir, the icon in the IPR field, who himself argued number of cases? That is a rarity. So what I feel is that National Law University system has immense advantages. If they want to change the syllabus, they can change within no time. For the same semester, it can be changed even once or twice also. That much flexibility can be seen. New subjects are added. A foreign professor or an eminent professor from a different institution can offer a course with 1 credit or 2 credits by residing with them with in 10 days, 15 days, 20 days. This is one advantage. And at the same time, I think we have to take some kind of holistic view. When we talk about the legal education in India, it's not those 5,000 and odd products coming out of the national law universities every year. We have to talk about more than 1 lakh students who are getting graduated from all kinds of national law schools and who really played a vital role, a pivotal role in nation building. And I don't think, the other day there was a conference of visitors, chancellors and vice chancellors of all the national law universities, under the chairmanship of Honorable Chief Justice of India. 16 Supreme Court judges who are visitors and chancellors, 16 State High Court Chief Justices also participated. I was looking at some of the products of national law universities as the vice chancellors or maybe visitors. I could find only one vice chancellor who can claim himself to be product of National Law School, Bangalore. Except Professor Sudhir Krishnaswamy, I found that everyone is from the traditional background. All the honorable judges and all the vice chancellors. The point I am trying to make out is that national law universities have served a particular purpose, but at the same time, I think there is a lot of, unfinished agenda. All the national law schools are not on the same plane. All the national law schools are not on the same plane. Like you talk about Tier 1 law firms, Tier 2 and Tier 3. National law schools also Tier 1, Tier 2, Tier 3. And they say that Tier 3 are worse than, maybe many of the traditional private law colleges affiliated to different universities. Just because we are using the expression national, it doesn't mean really national, truly national in every sense. However, they have the flexibility, they have the support of the government, they have the patronage of the judiciary, and they are catering to the needs of the maybe administration of justice. For example, one of the national law universities offers a unique course called BA LLB in Adjudication and Justicing. The title of the course itself is BA LLB Honours in Adjudication and Justicing. Look at MNLU Nagpur. It has started this. Maharashtra National Law University, Nagpur has started. So that flexibility is ensured in national law universities. But at the same time, I think as far as other, stakeholders are concerned, BCI has been playing certainly an important role, but there is a question mark on their involvement as far as the framing of the syllabus is concerned. And when we are shifting from teacher-centric education to student-centric education, especially in the legal field, especially when the young students can't keep themselves engaged or can't maintain their focus beyond 35 or 40 minutes, it becomes a real challenge. So we are graduating towards something called clinical legal education, more experiential learning, and the students are now talking not only about just internship, they are talking about assessment internships. Recently there was a big controversy until the Supreme Court put a temporary end to that regarding the attendance. Many of the students added one more fundamental right under Article 21 implicitly, right not to attend classes. You remember, until the Supreme Court recently stayed the Delhi High Court judgment. But there are challenges and they have to be addressed together by taking holistic view in terms of, as pointed out by Sir, equipping the students for ADR, alternative dispute resolution, maybe for ODR, online dispute resolution, by adding something like fintech, maybe, law tech, and talking about the cyber laws, talking about quantum technology, talking about interdisciplinarity, multidisciplinarity, and forget about the new education policy 2020, forget about it. But what is the need of the hour is something like, not treating law in silos. And with one last observation, I will hand over the mic to Mr. Nagaraj. We talk about BA LLB integrated course. BCom LLB, in Kerala it is very popular. BBA LLB. My first question that comes up, challenge which challenges my legal acumen is, where is the integration? Is there any integration between the law subjects and non-law subjects? This is $1 million question. And look at the syllabus. Honestly speaking, what is taught in BA in St. Teresa College and what is taught in BA LLB in government law college or maybe Mahatma Gandhi University or QSAT or Usmania University, almost it's the same syllabus. Where is the legal orientation? I think we require that kind of integrated approach. So lot of things need to be done, and the challenges are increasing manifold. I think this is the right time to take a fresh look at all these things.
Thank you, sir. And I think the kind of model new national law schools are forwarding, like the Sir G.B. Reddy sir was mentioning about the academic freedom and institutional autonomy when it comes to the curriculum building and all. Rest of us now started kind of inculcating to the state universities and all. Coming to Nagaraj sir, so you actually wear two hats, one with the Bar Council of India, Bar Council of Kerala, and role in legal education on one hand, and another one is like with Kerala Law Academy Law College, probably one of its first private law institution in Kerala. Both Sunil Thomas sir and G.B. Reddy sir they were mentioning about the post-globalization era, where the neoliberal economic policies have actually changed a lot in the country's political economy. It opened the doors of nation states, and that had actually created a lot of new opportunities. So they were discussing on one hand, one side of the story where a lot of new trade, IPR, technological advancement and all happening. The other part of the story is a lot more human rights violation, labor rights violation. It comes along with the liberalization policies and legal changes. So our legal education is really capable enough of addressing those part of globalization's impact. And in that process, what kind of legal education are you imagining, and how far we have succeeded in? Probably after I was your student in during the process of globalization. So our law teaching and learning, how far we succeeded in addressing the other side of the globalization story. And now we know that we have a lot of private law colleges emerging in Kerala. So the democratization process, is that happening through this or a commercialization process? So that we require a clarity on the expansion of private law colleges in Kerala in general.
So, respected Sunil sir, Reddy sir, and it always comes to me ARATI, it comes to me ARATI because her twin sister is whom I meet always. My dear friend Dr. Girishankar, principal of Dominic Law College, and former professor here, and my sir, respected sir here. And my friend SUNIL is Dr. Shinil Matthew, doctor, is also a faculty member now into practice. Now, I will start with what both the panelists said and what ARATI said. See, we have changed from this inclusive democratization to more of a little commercialization. But that is something inevitable, in the sense that I don't know how many of you have come across the facts which I am going to tell you right now. See, the first thing is, the topic itself is transforming legal education through curriculum modernization, practice oriented. Now, this is already transformed. The only thing is, we are blind. We are not seeing it. I don't know how many of you have seen it, how many of you have learned it. Because it is already transformed all around the world. And if you go to the United States, you take the Harvard Law School. You know how the curriculum is arranged there? You only have 4 core subjects there. Compulsory subjects are only 4. Unlike what you have nearly 50 or 40 to 50 compulsory. They have only 4 compulsory subjects. But again, all other subjects are optional. So you have so many options. They will give you 100, 200, 300, 400 courses options. Some may be 2 credits, some may be 3 credits, one may be 4 credits, like that. Options are given. So you have to complete the credits. You can have to select. You have to choose which all you want. Then some courses they will say, though it's not compulsory, it is highly required, essential. The purpose is like this. Some other courses, they will say this is very good for this area, it is good for another area. For example, sports law, because I have one of my colleagues now who was also my student in the NUALS, who has specialized in sports law, got a great, what you call as a placement in one of the firms, European firms, which is looking after club contracts in Arsenal, Barcelona, Real Madrid, like that. He could have earned millions, but he has dropped that job and come over here. He is now fighting for what, as ARATI said, it is not about what is it about right litigations. Now she is into democratization. He has left that corporate and he has come over here. So opportunities are too many. But there, a course is there designed saying sports law. Those who want, now they will tell you what are the opportunities you have, in which field you want. Like that it is there. So in some courses are done for just 2 people, 3 people, even for 1 person a course can be done. In Harvard, most of the courses out of this, you have to select maybe 60 courses, maybe 60 courses, out of that 20 maybe 3 credits, then another maybe 2 credits, like that you can select. Maybe 50 courses or 40 courses you may have to take. But you can select based on their description and based on, they will guide you. They will tell you what is the importance, where you have all these things. That is all there. Then you can select where you want. You want to be placed in corporate, whether you want to fight for justice, for rights litigation, for the downtrodden, whether you want to do for social and economic justice. It is depends on your perspective. Nobody can compel you. See, your mind is something so focused on what you call as money making. Nobody can compel you to do pro bono, right? It all depends on your aspect. But the importance of giving such pro bono service or free service, giving litigation services, social justice, economic service, that will be inculcated in you. They will tell you doing this course can help you such and such. They will inspire you to do such and such courses. So they can tell you if you want to make a name in such an area, you can do that. Like that, it is so inclusive. Then most of the courses there have less than 10 people for the course. Most of the majority. Only if some courses will have more than 10 people, 20 people. So don't have the feeling that teaching a very big classroom is what is teaching. Because it may be for 10 people, maybe 5 people. The course requirement may be not just lecture method. It may be a dissertation along with something else. So it is so innovative. And every time I would advise you to just go through the Harvard website. You'll see that every year they announce new courses depending on what is changing all around. Now what is the system we are having? Because as Reddy sir said, the national law schools are much better when it comes to other law schools. Now I am part of an institution which is almost 60 years old. By 2026 it has been 60 years since its formation, and the first batch by 2028, what we can say is there is Law Academy, it will be almost completing 60 years. Then almost for 40-45 years, this was only private college here. And I was in doubt as to how this institution was being run. Because almost at the fee of the government college, it was being run. Because of almost for 40 years, 35 years, all those who have studied there, studied at the same fees which people in the law colleges give. Because now I am quite amazed, or I am just surprised to, I don't know how it was being run at that time. It's very difficult. Maybe the people who brought money from outside to sponsor it. I don't know. But by infrastructure it was down. A lot of areas suffered. So students were benefited because of low, right? But only after the new law schools came here, now we have around 48 law schools. Then academy is also benefited, because academy could also charge more fees. Unlike the distinction was made between academy and other government law college. It was almost like government law college earlier, because fees wise. Because it was self-financing in fact. So now with other law college, they can also, the academy can also get income, and it started infrastructure development, all comes only because of this. So money is also a requirement. But I always say, maybe you know what is the fees Jindal is charging, you know, almost residential with this is almost 11 lakhs a year. So 5 years, your fees may be 10,000 maybe, I don't know. For 5 years you are studying for 50,000. Your counterpart in Jindal is studying for almost 55 lakhs. Then it's BITS law. They also study for that. If it is in Symbiosis, it may come down to 30 lakhs. If it is other law colleges here, and NUALS, it is only 2.15, sir, on 2.25, 2.6, which means only 13 lakhs a year in NUALS. So when you come to other private law colleges, because of restrictions on all these, you have 60,000, 70,000 maybe the fees. Maybe it comes to 60,000 means for 5 years it is only 3 lakhs. So you should know that it also entails a lot of economy, in the sense these colleges will have to spend 40 lakhs a year for maintaining the online sources like Westlaw, LexNexus, which you may be having, I don't know. Then so SEC Online, Manupatra, Heen Online, Justo, like that. NUALS is spending maybe nearly 1 crore, if I am not correct, if I am not wrong, because Kulvar arbitration is there, which is very rare. The students there are so fortunate, because last time when we had the EC meeting, because I am also an EC member, when we had the EC meeting, there was, sir, you may remember, there was a suggestion that we don't want Kulvar arbitration, because only 5 students have gone into it the entire year. So last annual year, only 5 years, it's valued at almost 14 lakhs, 12 lakhs to 14 lakhs a year subscription. Why we should spend 14 lakhs for this? Because I said this is a facility where only 5 people have looked into, right? Now the teachers have recommended. So I said the teachers should have an introspection, because now you are the people, only because of you only 5 people have gone into it. Now you are the people who should inspire them, encourage them to look into this, and the value of this. You are the people, the teachers should make them understand this. So such things are there. So maybe I will stop for the moment. So I said the teachers, it's their default, their defect, that students are not looking into this. Only when the students know that what is its value, why it should be gone into, they are given assignments on that, all then it will be looked into. So we said we'll not stop, we'll see that almost the entire student community uses it, so that their standard goes up in respect of arbitration. So such areas we can develop a lot. So as far as Sunil sir said, litigation as things are most important here. Now, whether it is right litigation by which we have, by each institution having autonomy.
This academic autonomy and the freedom. The undergrad course, we have a lot of designs and restrictions from the Bar Council of India. We are not having that kind of an academic freedom to adapt or regionalize or developing curriculum according to the institutional subcultures of different regional contexts. But in the PG level, because I teach a couple of papers which none of the universities in India is teaching for LLM courses. I teach this paper called Law, Science, Technology, which has a parallel kind of a course in Harvard Law University. And I teach a paper called Bioethics and Interdisciplinary Approaches in Law, which is none of the universities are offering. And another course I teach is Feminist Technology Studies and the Gender Justice Question, which is also none of the universities offer. So it's according to my expertise, I'll be able to develop my courses at the PG level. UG level is the problem with the BCI. So it's not the university level issue, which I want to just note it down. So I would like to come back to Sunil Thomas sir by asking, taking the cue from both GB Reddy sir and Nagaraj sir. Now we know that the level of fees, which is charging from students per semester, and we know that this process is, if we inevitable, many of you argue, but it has a dimension of question of social justice. So one of the major criticisms against national universities are regarding the question of social justice. Who will be able to apply for a CLAT entrance? How much are they charging for that? So starting from there, a invisible elimination of certain class and certain community background students we can see. So the commercialization of legal education is a reality. In that context, what will happen to the very idea of constitutional values, which is 15 clause 4 and 16 clause 4 and all arguing. So one of the argument is it is actually conflicting with the idea of the social justice within the legal studies. Who is able to access this premier institutions? And those who are within, coming with that kind of an education, how far they will stand for the idea of social justice in both ways. So one is within the entry to the law school, what is happening to the question of social justice. One, the exit of law schools, how far they are standing for the idea of social justice. So how you have a lot of experience as an academic, as a jurist. So we would like to listen from you. How do you see this dilemma or a problem, or how we can think forward?
See, I would like to view that point from slightly different angle. See, one is qualitative. I am totally not against the National Law University concept. Because you just see how many persons aspire to get an admission in a National Law University. At least 40% of the graduates, they do, and only the best get. Is it the only field where we have such a high paid service going on? What about private hospitals we have? What about private institutions we have? The typical example is that General University. So why should we find fault with the concept of national university system? See, Jindal is also a private institution which is charging very, very high. Still people go there who can afford to go. Of course, there is another sociological aspect, as Dr. ARATI said. What about poor people? See, even, but there is one thing you should understand. See, what about the private law colleges and government law colleges that we have in Kerala? The quality of teachers are far better. At least I will say they are equally good. And persons who belong to the middle strata or the lower strata can join a college. Still, ultimately the question is, what is the quality of the output? I agree with Dr. Reddy on one aspect. See, most of the students who come out of the national law schools, they don't go for practice. Very rarely, because when we go to a law school, national law school, for any interaction or a seminar or a discussion, I find good quality students there. No doubt about that. Let the cream also get a good education. But they are carried away by the corporate culture. Most of their also the person's ambition is to join a corporate institution in Bombay, Madras, Bangalore or Delhi. They don't go for regular practice. There are typical other examples also. I'll tell you. Typical 2 examples of a lady lawyer who did her LLM at Singapore on mediation or shipping law. Because Singapore is the best college where we have the shipping law. Practicing in Kerala. Another lawyer who had his LLM from Cambridge. Practicing in Kerala. You see that also. So that what I am saying is that the concept of national university should not be looked at from the sociological aspect alone. Let the cream of the society get the cream of education. It doesn't mean that other students in other colleges are backward in any sense.
when they come to practice, they also shine. They set up good practice. Just come and see how many lawyers are practicing in Ernakulam, High Court of Kerala. Doing well. And the institution is going ahead. They are making money also. But of course, that qualitative difference will always be there. So I'm not, my answer to this is not that way. You should look at from two aspects. One is what is the quality of the products. Secondly, how far it caters to the necessity of the society. So that's what I have to say. Thank you. Thank you.
Thank you, sir. And probably GB Reddy sir is kind of in a defense mood. And no. Okay. No. It's like we know that the larger political economy after this Birla Ambani report and all, its investment in the higher education state is withdrawing. And that is the scenario, and we understand the largest scenario of it. I'm asking a question which comes from a different kind of a perspective. How far our institutions are successful in developing critical thinking? Because many of the classrooms now, they become kind of you were talking about student-centric way of learning and all. How far we are successful when it comes to the idea of critical thinking, especially a subject matter like law, which requires a critical thinking to have an idea what law ought to be. That is also one of the mandate of legal studies. So as a teacher, what I feel of late is we are teaching what law is, and at the same time we are failing when it comes to the question of what law ought to be, which requires a proper kind of a training in critical thinking. Being part of academics for such a long time, what is your reflection on our institution in addressing the idea of critical thinking?
Okay. Before I say something on critical thinking, I would like to dispel a myth or a popular notion that national law schools charge a very high fee and probably there is commercialization of legal education. Now I have one of my good friends and EC member sitting on the dais. Today we have almost 91% of our fees being paid only for salaries. State government hardly gives us around maybe 2 crores or 2.5 crores with lot of prompting and prodding. They have their own limitations. We are not criticizing anyone. But in order to maintain, for example, how to subscribe to law resources, the library resources, by spending 1 crore rupees. And I think that is possible only when, so it is almost a kind of self-sponsored, education. Only online sources. So that is one important aspect, but quality also matters. Second thing is about the social justice concept. Honestly speaking, Kerala is leading in this particular aspect. And we have the social justice concept totally imbibed in the admission process with regard to catering to the needs of different sections of the society, state reservation concept, local reservation, so on and so forth. And the second one is, I think even this vertical and horizontal differences are mostly, in fact, brought down to the greatest extent. That is one important aspect. Now coming to critical thinking. Honestly speaking, in general, critical thinking is missing among all the law schools, and the critical thinking is a little higher in national law universities. So it is like the Montessori system, where the students ask, why not? Not as to why, but always why not kind of thing. And many of the critical studies are made in the national law school system. It's not stereotyped, it's not law positors like as it is we are learning. Honestly speaking, many of the projects, I'll give you project 39A. Look at Mr. Anup Surendranath's project which started in NLU Delhi. Now, lock, stock and barrel, the entire team has shifted to Nalsar Law University. And look at the kind of work done by them in the area of free legal aid. That is something remarkable. So, almost all the national law schools have centers of excellence through which they are coming out with their own studies and, in fact, giving policy inputs also. That's equally important. Keeping in view the contemporary international and national developments and needs. Certainly critical thinking is evident, but not as much as it should have been. That is one important aspect. But at the same time, they are in a tearing hurry. The moment the fourth year is over, everyone is after placement, because they want to be placed in the fourth year itself. In the fifth year, just they want to join some, law firm or other, or maybe higher studies, maybe something else. But at the same time, the criticality or critical approach is very much evident in the national law schools. That is one important aspect. And as far as adoption of the various other models, for example, technology, so on and so forth, I feel that legal education is one area where there can be a level playing field. Irrespective of the background, irrespective of the, maybe the institutional affiliation, I think a student studying in government law college or university law college affiliated to some university like Usmania or Mahatma Gandhi, whatever, they can do much better as compared to the students coming from even corporate law schools. I have seen that great potential, and here they must always feel that there is a level playing field, and there indeed is a level playing field. And because 90% is on us and maybe 10% is only on the circumstances, I think we have to tide over that, and everyone must realize that whoever has made it very big, very successful in their respective careers, right from Municipal Magistrate to the Supreme Court Chief Justice, all of them came from this particular background. There is no competition for you. There is no competition at the top. It is that approach which we adopt.
So I think we are running out of time to Nagaraj sir.
Yes.
How do you see the role of Bar Council of India in interrupting the academic freedom of law colleges rather than governing it? And where do you see the Bar Council of Kerala and its role in kind of pacifying or in intervening in that matter?
See, the issue is regarding the Bar Council of India, there is only one member from each state Bar Council. From Kerala, one member. From Tamil Nadu, one member. It's a different field as such. So as per the Advocates Act, the role of the State Bar Council in laying down standards of legal education, a curriculum, is very, I can say it's almost absolutely nil. I have no role at all, the State Bar Council. So as a member of the State Bar Council, I know we don't get to, even if we discuss and we send it to them, they may not, because it all takes place at the national level. And I'm sad, or I would take the risk to say that the Bar Council of India has failed itself in laying down standards. Now it is years behind, or decades behind what is required. So it's running, even now it is running almost 30, 100 years back, what was there. Now this institution is in, what is the year 1894. Now I forgot to tell you, because the persons who introduced us failed to introduce us, that I was also a teacher here for almost 5 years, from 97 to 2003. And Sunil Thomas sir was also a teacher here before practice and becoming a judge for almost 5 years earlier. It's, if I'm correct, 85 to 1990. So we also had some experience here. So I can tell you that when it comes to the Bar Council of India, it has failed for several reasons. Because it is not being innovated, it is not being updated. Now all conventional styles are still going on. Maybe one reason is that you have almost thousands of colleges where you cannot innovate, at least. But as far as the new universities are concerned, they have the freedom. But the other colleges are concerned, but there also something has to be done. Because I don't know who will do it, who will bell the cat, or who will do it for the Bar Council of India. Because anyway, I am not there. So I am only a member of the State Bar Council. Because I can only, just like looking at the moon, I can only see at the Bar Council of India from here. So it's something like that. And about the money you spend about this inclusive, the absence of inclusiveness, because people from poor background may not have access to these corporate law schools and all this. I can tell you, just take for example one interesting story which happened during the Prime Ministership of Vajpayee. At that time, when Murli Manohar Joshi assumed the office of the human rights as human resources minister, he thought at that time it was almost 2 or 3 lakhs fees for IIT. IIT, that is number one. Because I know almost 5 lakhs, 10 lakhs, 50 lakhs people write for IIT and only them some 1,000, 2,000 get. He said, how can poor people achieve this? I want to bring down the fees from this 2 lakhs or 3 lakhs. At that time, 2 lakhs is a very big fee. Then the students and teachers started a agitation saying that we want to increase it. See, they started saying that they want to increase it. The reason is, these are brands where even Singapore came to us. We copy everything from Singapore. Singapore came to us and asked, they don't want Singapore Institute of Technology, they want Indian Institute of Technology there. We did not, the government of India did not permit them. The issue is, when I was studying, I had almost 30-40 doctors with me who are working various places. But everybody's first desire was to have an IIT admission. The best. If you get an IIT admission, banks will come after you. They will come after you. There will be a queue after you saying that we will sponsor you. We will sponsor you. Please. And even if you say we don't want any loan, they will be after you. See, that is the status you get for such institutions. I'm telling you, see, Jindal may be 11 lakhs a year, but the same you can give, the same standards and quality if you can give at 1.5 lakhs or 2 lakhs as NUALS does. Maybe a yearly 10 lakhs or something, if you are assured of something, then definitely loan is a good option always in such cases. I'll always say. But provided it should be something good as IIT, not everywhere it is there. Then second thing is, I can tell you, see, this old, this thing we said about, now this institution is 1894, right? 1894. See, Harvard started in 1817. And they offer a lot of scholarships also for them. That is also required. I don't know Jindal is offering how many scholarships. They say about scholarships, how far they are offering, I don't know. So brilliant people from other socially deprived economically deprived backgrounds, there are scholarships in Harvard, because Rajkumar, the Vice Chancellor of Jindal, he said at that time it was, he cannot imagine how he could study. He studied in the Harvard by scholarships. He said it was affordable because I got scholarship. So these are also there. So we should also think about that. And I can tell you that, see, these 11 lakhs, you can always, 1.5 lakhs, the same standard can be achieved. It is possible, depending on the intention and how you balance with various rights. As Sir said, NUALS we are spending 90% for the faculty salary, 90% salary and library staff and administrative staff, faculty and all these 90%. For infrastructure development only 10%. So that happens there. So when it comes to rights violation, you said about that issue, because all people are going into the corporate field. No. Because I find a lot of people in the High Court, the trial courts, who are protects from the National Law School, Bangalore. Because Bangalore, there the issue is even Indian firms are not getting recruitment from National Law School, Bangalore. Sometime earlier, if I am correct. So Singapore and other firms were getting, the top were all taken. But there are people who are rejecting such offers and coming for practice. Even in the trial court I have seen people who are practicing who also do pro bono and also charge fees, adequate fees. So such things are happening there. Then another issue is about the critical thinking. Critical, you should have journals, you should have research journals, critical thinking, and always we should assess the standard of the institution by the output, what they are giving, what is their contribution to society. Because if you say about the Harvard, they have contributed a lot. The affirmative action, which is similar to our reservation policy in United States, is based on their research, their output. Their output has resulted, just like Reddy sir was telling, legal aid. Now the present day free legal aid and legal services have been developed through research in the national law schools. Like that, what is our contribution? This institution, does it have any contribution like that? What have we contributed? To law reform? To the society?
There's a difference of opinion.
Yes.
Because even before the Legal Service Authority Act came into force, Law Academy had made distinct contribution to the legal aid, to Committee for Implementing Legal Aid Schemes way back in 1980.
Yes, my friend, yes, Dr. Girish Shankar sir, he was earlier part of Law Academy. At that time, of course, we have started. The point is, Law Academy started at that point, but it was still, it has gone only down from there. It has not gone up from there. See, we have started there, but after that, lot of developments have taken place. No, I went to Symbiosis only 2 years back. Now, they were in this NIRF ranking, they were ranked number 1. So I just wanted to see what made them rank 1 above the national law schools. So I went to Symbiosis, I met Shashigala, Dr. Shashigala, who is the dean, and I had a discussion with her. And one difference I found was the legal aid clinic there. The legal and social aid, social service clinics. Giri sir, I was telling, see, now we may have been innovators, we have been the pioneers. But how far we have developed from that? It has gone a lot. Now I was telling, NIRF ranking, Symbiosis was number 1 in 2023. So I just went there.
Because this is a particular area which is having the scope for high debate. Okay. See, we have got 4 government law colleges, public educational institutions. What exactly is the financial outlay for each law college? It's a big sized amount. It's a big sized amount. Some 8 or 9 years back, we had, no, I think I'm audible, right? Yes. So we had average 42 lakhs allocation for our library. Government Law College and Government Library.
48 lakhs.
42 lakhs annually we have spent.
That's not enough.
No, thing is that, but what is the output? See, if you go through the first floor of this institution,
Yes.
this is more than a library, it is a museum where you have got quality legal journals, premium law journals published across the world, is confined to, safely confined.
Yes.
Isn't it? More than 12 or 13 journals are there. So again, when the government spends this much amount, there also, I think, barring the faculty, compensations, etc., and there is a subsidy, isn't it, for each student learning, because that is why fee is very low. Then what is the output of every single public educational institution, at least 4 law colleges in this state? See, all these things have to be reckoned. That is one thing. Secondly, this session is on curricular reforms. See, in the existing curriculum, can't we find adequate leeways where we can innovate through multidisciplinary courses, value-added courses, bridge courses, etc., which could compensate the shortcoming of the existing syllabus, where the syllabus revamping is a big issue. Big issue. For example, June 1st, we are having college reopening. New labor codes have come. The university is not ready with the...
Take another 3 years.
The university is not ready with the syllabus accommodating, or rather including these 4 labor codes. can you teach a batch of students the non-existent legislation, and if they apply for any programs outside India for this one for their higher studies, even their transcript will not be the syllabus is to be sent, that will not be accepted. So likewise, so there are certain issues, but within the existing framework, can you make good the shortcomings through innovations? So the curriculum should be innovative, the syllabus should be innovative, but whether innovation can be accommodated or these sort of new content can be given in the existing space itself, that is also to be explored. Who is to be explored? That is one thing. Secondly, why can't there be a grid to be developed between the law across the state, at least at the government level? Because the budget allocations, there could be a synergy, or a difference, isn't it? So likewise, coming to private law colleges, and my experience is from switching the flanks from a government institution where I was neck deep involved to a private education institution. I find more opportunities for private education institutions only because of the fact that there is no red tape visa. You need not send letters to the Principal Secretary Higher Education and wait for a letter which will never come, reply which will never come, because decisions can be taken at the lowest level. Slowly what is going to happen is that if the public education institutions do not adapt to the situations, and then the government, the regulator, the government do not sense this particular issue, then nobody can prevent the coming up of private universities or private colleges, whether it is law colleges or other colleges, which has got disposed of their resources and functional autonomy even at that particular level. This is going to happen.
Just a minute,
one issue I was not able to complete was regarding legal aid. What I was about to tell was, because in 2023 the Symbiosis was ranked 1 in the NIRF ranking, so I went there to see what was there, and I found, so one difference they made was that their legal and social services clinic was extraordinary. I was amazed to find their documentation. No, they had a 24/7 service center, not just for legal service but also for social service, and the amount of work they have put in, I was amazed I was not just surprised, I was amazed to see what type of work they have done. The volumes of work they have done in this area. So documentation, then just what, yes, and everything what I said, I do appreciate and agree with what you said. Nothing more to say about what our Dr. Girishankar has said.
Yeah, I'm sorry for the time constraint and stopping you, Nagaraj sir. And so this is something, I think it's an ongoing debate which we all are part of, and I'm really thankful that those who are the center stage of this legal education definitely are students. And when we make any kind of curriculum change or any kind of structural changes, we hardly get opinion from students. So in a student platform, in a national conference organized by the students, I would have expected one student representative in the panel, so that students' voices would also could be echoed here. So for that, I would like to open the floor to listen from the students. What do you think about the current legal studies, and what kind of changes would you like to expect, or what kind of a transition towards achieving the kind of an egalitarian social justice society which is in all of our minds? What the way in which legal education has to be transformed? What is your ideas? This floor is opening for such suggestions.
My question is that, we are actually successfully expanding the niche jurisprudential areas also. Like we are being taught about Schumpeterian theory, this theory, a lot of doctrines in the classrooms. But our teachers, they are not having the exposure. They are not going to the courtrooms. They are not going to the corporate offices, and they basically are not aware of the modern non-traditional job profiling. Say for example, when we are going for the internship, they are asking us for the redlining of the contracts. They are asking us to actually read and identify those problems in the, or do the flagging in a contract. And we know that in the current setup, the BCA also mandates that the teachers are not supposed to go for a full-time or they are not supposed to go and actually practice in the court of law. So my question is that how can law schools overcome this limitation to ensure our graduates, that is we, the BALLB, BBLLB people, aren't just learning the jurisprudential aspect, but we are actually learning much beyond that. Like we need experiential learning. We have to actually understand, and we have to be also be practice ready, because at the end of the day, we are all coming over here even to earn money, because our parents, we are actually sending us because it's the bread and butter. So we have to be market ready. We also have to know like what exactly and how we have to go and practice. So what can be the steps that can be taken in the current social construct? Thank you.
We can take up a couple of questions and then.
Just I want to say something about the decentralization of power has not taken place in anywhere in India. All concentrated in some pockets. I know as an administrator, vice chancellor, professor, everything as you have said, everything I look at the moon. Yeah, but I have done excellent work even with this framework. When our education minister Joseph said that 2,000 seats are allotted to Kerala for engineering, I immediately got his permission NOC. And I started an engineering college and landlord is doing. I have the syndicate, senate, faculty, money, finance, budget, nothing. I started the engineering college. It goes one of the best in for the last 20 years. Now I don't know. So the power decentralization, syllabus. I asked for a syllabus for those who are studying history. Economics should be there. But the Board of Studies told me, no, we cannot teach economics. It's another discipline. Without economics, how you can teach history? So many things are educational problems. And I wanted to point out sharing of the books for all the district. You can standardize it and information, you can pass it on, which book is available. And also I know, please excuse me, the justice, when they are treating with land revenue laws and other things, they don't know what is the difference between Malabar and South Kerala. And on account of South Kerala, 32 villages are very backward in India, like Bijapur. And I have organized a committee for the Tulunad Development Foundation with the help of others. Thank you very much for giving me.
Good evening. Ma'am, for the question regarding student representation in this panel, my answer is to provide equitable education and equitable opportunity to all legal scholars, students of law in India. That is, I am a student of law from a private law college in Kerala. My thing is that since I really appreciate the words of Reddy sir. We have already talked about the importance of establishment of NLS, National Law Schools in India. For a private student like me, NLS acts as an inhibition for an opportunity for me. As a private law student, can I aspire to become an intern at Tier 1 law firms like Cyril Amarchand Mangaldas, Tri-Legal, Shardul Amarchand Mangaldas? No, I cannot even dream of. What they are looking for is the college we hail from, the institute that matters. Your Lordship, your Lordships and Sirs, the subject of law is very different from other subjects. This is man-made subject. Other subjects like medicine, engineering are integral part from what kinds of institute we study, the techniques that we study. But unlike law, which is man-made, it's up from the perspective on how we understand particular subject. So these kind of national law schools inhibit these ordinary schools. Most of the students who are sitting here are not from national law schools. They are from ordinary law colleges, from government law college, as well as other private institutes. So how can we ensure, or how can I aspire to become a part of such tier 1 law firms or tier 1 institutes like that?
I think we will forget the questions if there are more questions.
Good evening. So my question is basically from the very concept of what the question was from him. So I'm basically from I'm a student of GLCE, Government Law College, Kozhikode. And I would like to question that whether the national law schools is the very allied section of law schools, I know indeed. And the question is, this national law schools is having a great gap between the government law schools. And we do feel that indeed. So in this scenario, how could we maintain the gap bridge that gap. So as Sir was signifying that innovation that should be brought out in the upcoming syllabuses in the curriculum, we are also aspiring in such a manner. We will be, sometimes we will be also in that along with those very high allied students of the NLUs. So we do aspire in such a manner. So, but the distance or the gap between us, the government law college students, as well as the allied sections of people who are passed out from the national law schools is a huge one. So our aspiration has that gap. And what are the innovations, or how can these innovations be made in this government law college scenario?
Sir, I was actually listening to a similar lecture on same topic, almost similar by Justice Nagaratna ma'am. And the issue was about the large number of students who have actually graduated in law failing the AAB examinations. About 33% failed, and in 2023 failure rate was 55%. And ma'am pointed out an interesting perspective. She said that about 90% of the students who pass or get a law degree doesn't even know the full form of LLB. They are not even able to say what is LLB standing for. And in such a system where the students doesn't even know the degree that they are getting, how can we ensure that this is a quality education that they are getting? And she pointed out that there is a trifecta in education system. One is the resources, the other one is two inputs. The two inputs is one who trains and one who is being trained. So what happened is there is a large number of private institutions which have opened up, and that has actually cut down the quality of the students who get into legal education, because the cutoff marks is just 10 marks that is needed in an entrance examination to get into legal education. So people who don't have the legal aptitude get into legal education. And the other system, which is the trainers, no good teachers are actually, the lawyers are actually coming into educating or teaching profession. So what happens is we have people who are studying law who are subpar, and teachers who are subpar, and system which is also subpar. And this trifecta is a dangerous combination which is, this subpar. So it is actually creating a dangerous trifecta that has actually, the quality has been reduced due to this. So an innovative structural change has to be done in this trifecta. Yeah, so my question is, what do you feel that, how can the teachers system can be developed in this arena?
Respected dignitaries on the dais, I am actually a practicing lawyer as well as faculty in National Law School, guest faculty in National Law School, Kalamassery. So, from the discussion that happened earlier, like there was a statement made about the students who are aspiring for corporate jobs more. But from my experience, from what I have understood from the interactions with the students, most of them want to get into litigation. But two reasons are there which is stopping them from doing that. First reason is that what they are learning, because of numerous internships and all that they have done in courts, they are understanding that what they have learned in college and what they are going to practice is two different things. There is a parallel system of law that we are learning in college and a parallel system of law that is being practiced. So that gap is there, and that gap is one of the reasons why students fear coming into litigation because they feel that they will take another 3-4 years to learn that system. Second thing is the low pay. Corporate actually gives you a good pay. For you to get a good pay in litigation is difficult. The pay part, I don't think academicians will be able to make a change in that. But at least in the part of the difference between the law that is being practiced and the law that is being taught in law schools, what can be done about that? How can we bridge that gap? And also bringing in practicing lawyers in many of the subjects like CPC, CRPC and all. If an academician, pure academician is being given the task of teaching them, they don't have the necessary knowledge or know-how about the practicality aspects. So that has to be changed. But at the same time, subjects like jurisprudence, you can't expect a practicing lawyer to have a know-how or a knowledge of jurisprudence like an academician because they are going in depth into the subject. So my question is, how can we bring in a change to bridge that gap between the law that we are practicing and the law that we are being taught in law schools? And how can we improve the new budding lawyers' condition as to their income sources and all?
I'll answer that. I'll just answer that. We will go back to the other question. See, probably your question is exactly the same what she asked. See, what you learn in a college is slightly different from what you practice. That is not something peculiar with this profession. Every other profession is always like that. When you put a principle or theory that you have learned in the law college or in any other education, it will be slightly different, but not as wide as we have in the law colleges. True, I agree with you. But see, your question gives the answer itself. See, when the paper of jurisprudence, legal history, interpretation of statutes, why should you expect a practicing lawyer to come and teach you? So there was even a system of trying to bridge that gap by having practicing lawyers as part-time lecturers. I worked as a part-time lecturer. Nagaraj has worked as a part-time lecturer. Girishankar has worked as a part-time lecturer. Several. See, that's how you try to bridge the gap between one method of. That's not there. Second is by doing your internship. This is something which you all, very peculiar method of internship. In my Central Administrative Tribunal, every week interns come. They do attend the court. I interact with them. So that's one method of it. And when we were studying, we came just out of law college without knowing anything about the actual practice. So to that extent, you are much better. So don't expect every subject to be taught by a practicing lawyer. Then equally competent lawyers or teachers who can teach you on the basic principles of law are there. Then secondly, the wide gap between the national law schools and the government law colleges. Because your concern is that you don't get a placement in Amarchand. See, there are umpteen number of institutions in India spread over various high courts, high court centers, which are good. They pay you. Then another concept, another wrong understanding about the corporate law culture is that the corporate employer, corporate firms pay you high. This is only at the beginning. Once you go to a corporate law firm, unless you become a partner of that, your career is doomed. I'll tell you, very, very frank about that. You get a pay, you give the incentives, and your work time is 24/7 into 365. They extract much from you. And you will remain always as a junior attached to corporate law firm. But on the other hand, if you are a successful lawyer, Sky is the limit. Even by practicing in a magistrate court, you can make money. Even by practicing in a municipal court, you can make mint money. That's it. So don't go by that. Then the next one is National Law School. There is no question of National Law School versus government law colleges. You try to bridge the gap by not reducing their quality, their system, but by improving your quality. Then thirdly, the payment that they make in other private colleges which you make is towards the infrastructure. Quality of teaching probably doesn't make much difference. This is what I have felt. So what would you do?
I'll be brief. Probably there is a caveat. First thing, in response to the young lady who posed that question, there is a misnomer in India that the teachers are ill-equipped to teach practical subjects or clinical subjects, which is totally false. Nobody prevents the teachers from updating themselves. There are wonderful programs like the faculty development programs, competency development programs, orientation courses, refresher courses, and if any teacher would like to in fact equip himself or herself with the practical subjects, they can do much better. There is another possibility of many persons who practiced law coming into teaching. That is second aspect. They can teach probably CPC, CRPC, now BNS, BNSS, etc. a little better. But at the same time, please remember that theory and practice are quite distinct. And the theory which is taught, even if it is taught by a practicing advocate, will not be like a court. And you will still find the differences in the real court. Even if a practicing advocate with 25 years standing comes and teaches a practical subject, a clinical subject, still you feel that there will be difference between, or there is difference between what exactly is taught in the classroom ambience, even with the help of simulation exercises, etc., and also what happens in the real court, real issue or real time litigation. This is one aspect. Second thing is, very unfortunately, many bright postgraduates in law are not coming towards teaching profession. Probably, their ambition may be something else. And UGC scales, if they are really paid, they are much higher. Honestly speaking, they are much better, sometimes even compared to the civil servants. At the same time, there is an unspoken truth. Nobody wants to speak about it. In 90% of the private institutions, not even basic scale is paid. There are honorable exceptions. KLA may be an exception. I am not saying anything. But at the same time, they have their own practical constraints, especially in the case of unaided colleges. When they don't get any aid from the government, they have to run the show. Therefore, they keep on engaging the teachers who are either visiting, temporary, ad hoc. The net result is something else. This is one point. But there is a possibility of improving the quality of theoretical education as well as clinical legal education. Don't be contemptuous towards the theory. Theory is the basis, foundation, and the practice is the superstructure. Without theory, there is no superstructure. And this is one important aspect. And you must know that before Advocates Act 1961 came into force, advocates were competent to teach law as full-time teachers. Just LLB was sufficient. LLM was not required. 2 years law course was sufficient. But if you look at the 14th report of the Law Commission of India, under the chairmanship of MC Setalvad, he says the present system produces half-baked lawyers. Half-baked lawyers. I am talking about 1959 or so report. That system has changed. This is one aspect. Second thing, I will be very brief, about the national law schools and others. As Sir rightly pointed out, national law schools are intended to become IIMs and IITs, so on and so forth. And there is a possibility of constructive collaboration between even the national law schools and others. It's not only consortium of NLUs. They can handhold. Like, We collaborated with a private law college in Bangalore in order to conduct a hugely successful program recently, last month. We are in Kerala, they are in MS Ramaya. MS Ramaya is in Bangalore. But we collaborated. And we must be open-minded, positive enough to, in fact, work with everyone, because as long as we maintain the concept of TLC, Traditional Law College, National Law School kind of thing, that is going to increase the gap. Bridging the gap will be very difficult. Last point. Honestly speaking, yes. Sir, at the cost of saying something about me, I'll tell you, even though I am associated with number of national law schools, including NALSAR as its academic council member 2 times, general council once, and 3 other national law schools, when I was appointed as the Vice Chancellor of NUALS, there is one particular website where it was mentioned that so-and-so was appointed as the Vice Chancellor of NUALS. Then one of the comments was that he is from a TLC. We only hope that NUALS will not become another TLC. Then there was a response saying that no, we know him very well, he is an excellent teacher, good administrator. Anyway, let us hear from the students of NUALS. So this is the kind of feeling among many of the so-called National Law School faculty and students also. What I am trying to say is that everyone who is manning should be competent, whatever may be the origin. And the last point, there are Tier 1 law firms, Tier 2, Tier 3 law firms, all of them are not on the same footing. Similarly, Amarchand Mangaldas may be taking only the students from Tier 1. There is a discrimination against Tier 2 and Tier 3 law firms also, which is a fact. I think here, ultimately, the competency will speak over a period of time. As Sir pointed out, Amarchand Mangaldas or the like firms are not the only firms. You can create. And one funny thing which our elders used to say, if you are really, in fact, believing in yourself, if you want to be part of the legal profession, for first 5 years, you may not have work, you may not have any pay. Next 5 years, you will have the work and you will have some payment. And for the next 5 years, you will not have any work, but only the pay, only the money. But you have to reach that position after crossing the first 2. And this is what, I think once you come up to that level, you just take any leading advocate in the High Court, in any of the lower courts, you will find that many of them came up the hard way. There are few very successful NLS products. I am not saying anything against them. They are good, brilliant, but others also have the same, believe in yourself. That's the only thing.
Thank you, sir. Thank you all the panelists, Justice Sunil Thomas sir, Professor G.B. Reddy sir and Nagaraj Narayanan sir. And thank you for the comments from Professor K.K. and Kurup sir and Dr. Girishankar sir. And thank you for all the questions and your patient listening. And I think it was kind of an active listening even after a post-lunch session. And we will continue, take away from this session, we will continue these discussions in your peer groups, in the classrooms, and your continue this discussion in the Bhagat Singh study circles, in all other platforms which is possible. And we can have later on a revisit on what kind of discussion and further deliberations and how we can look forward to a transformative legal studies structure in India. Thank you all, and over to the...
Thank you, ma'am. That was indeed an insightful session. Now, as a token of gratitude, we would like to present mementos to our esteemed dignitaries. May I respectfully invite our principal, Dr. Professor Bintamol VC, to present the mementos to our esteemed guests. I request ma'am to present the memento to Honorable Justice Sunil Thomas, former judge of the High Court of Kerala and judicial member of CAT, Ernakulam bench. I respectfully welcome Professor G.B. Reddy sir, Vice Chancellor, NUALS Kochi, to receive the memento. I welcome Advocate Nagaraj Narayan sir, BCK member and Director Kelly to receive the memento. I respectfully welcome Dr. ARATI PM Ma'am, Assistant Professor, MG University and Moderator of today's session. Thank you, ma'am. Thank you, ma'am. As we come to the close of this session, I now invite Ms. Adina, Joint Convener of Bhagat Singh Study Circle, to deliver the word of thanks.
Good afternoon, everyone. On behalf of the organizing committee of the National Conference, I extend our sincere gratitude to all who contributed to the success of the panel discussion on roadmap for transforming legal education through curriculum modernization and practice-oriented learning. First and foremost, I express our sincere thanks to Justice Sunil Thomas, former judge of the High Court of Kerala and judicial member CAT Ernakulam bench, for chairing the session and guiding the discussion with invaluable insights and vast experience in legal field. I extend my deep appreciation to Professor Dr. G.B. Reddy sir, Vice Chancellor NUALS KOCHI, for sharing his valuable insights on the evolving landscape of legal education in shaping future legal professionals. I also express my sincere gratitude to Advocate NAGARAJ Narayanan, BCK member and Director KLA, for highlighting the significance of practice-oriented learning. Your thought-provoking contributions have provided us with a clearer understanding of the reforms and innovations necessary for strengthening legal education in the years to come. Our special thanks also go to Dr. ARATI PM, Assistant Professor, School of Legal Thoughts, MG University, for efficiently moderating the session and facilitating a vibrant and engaging exchange of ideas. We are grateful to all the delegates, academicians, legal professionals, researchers, students, and participants for your active involvement and thoughtful interactions, which greatly enriched today's discussion. Finally, I thank all the volunteers and those working behind the scenes for their dedication and efforts in ensuring the success of this session. With sincere gratitude to each one of you, I conclude this vote of thanks. Thank you.
Thank you, Adina. Once again, thank you to Honorable Justice Sunil Thomas sir, Professor G.B. Reddy sir, Advocate NAGARAJ Narayanan sir, and Dr. ARATI PM. Thank you.